Good morning and welcome to this Field Seymour Park's 10th annual Employment and Immigration Law Breakfast Briefing. Thank you very much for attending today. My name's Ian McRae. I'm one of the employment partners at Field Seymour Parks. And today I'm delighted. I'm joined by Imelda Reddington, who heads up our immigration team. Morning, Imelda.
Good morning, Ian. Good morning, everyone else.
Yes, good morning to everyone. So obviously we've held this at various venues sort of throughout the years, but we are sort of remotely today. For those of you who were here last year, you will see I still haven't decorated my spare bedroom, but one day I will. Now, as it's our sort of 10th time we've run this particular session, we wanted to do something to mark it a little bit. Some sort of party with cheese and wine was obviously considered, but decided against that. And instead, we're supporting Launchpad with this session this year. So we've obviously been talking about sort of employment issues for 10 years. It seemed appropriate to support a charity that helped people back into work. So giving you some details on the slides there, including where you can find out more about them, their sort of various social media platforms. But by just attending today, the firm is basically going to donate £2 for every delegate. So just by turning up, you're raising money for Launchpad. And equally, if you for everyone who sticks around and sort of completes all the interactive polls we're going to do, we'll add a further £1 for every delegate, every attendee who does that as well. So another reason to stick around and listen to me and Imelda for a bit. But let's deal with some of the admin bits before we get into the content. Obviously, we can't see or hear you, but we would love to get your questions. We're going to be leaving time for that at the end. So you'll see the question box on your little webinar dashboard. Please click into that, type in your questions, and we'll open that up at the end and we'll do the best we can to answer those. As I say, various sort of interactive polls. And please do sort of get engaged with those. Helps us know that we're not just sort of talking into the ether, that there is somebody out there listening to us. And if you want the slides, they should be in the handout section. You can download them off there. So that's there. And then the final thing I'll note is there'll be a feedback form at the end. So once we've gone through the questions, I'll close it down. Feedback form, a couple of questions, only takes a very short period of time. If you can fill that in, that would be really appreciated. Helps us know what to do for future events, and equally there's a prize draw on that as well. So if you get drawn out the hat, you could be a lucky winner. There's also the ability to sign up for all the different updates, content, etc. that we produce, and that's on the immigration and the employment side. Right, so that's all the admin bits. We've got loads to get through, so I'm gonna crack straight on. Essentially, we've got it in sort of two sections. So you've got me for around about the first 45 minutes today, talking about some of the employment law topics. And then I'll hand over to Imelda to pick up some of the immigration issues, so the last half an hour, and then we'll have questions at the end. For my sections, starting off, somewhat unsurprisingly, probably looking at COVID, seeing some cases come through relating to the decisions that employers made. So we'll be looking at those, what can we learn from them, and also looking forward to some of the challenges that there might still be. Flexible working, some high profile decisions that were in the press recently and some changes forthcoming there. Equally, sexual harassment, hot topic, and again there's some proposals for change, and the new employment bill which we're expecting this year. I'll talk about all of those, and then I'll hand over to Imelda to talk about immigration routes and some changes to visas, right to work checks, and some sponsorship IT reforms. Right, before we get any further, I'm going to ask you a question, just to check there's somebody out there. And this is a question, and you should be able, hopefully, to see that now. This is a question asked last year. So it's about your HR priority for this year. You can vote whenever you're ready. Essentially giving you 5 options here. So it's restructuring, cost cutting, recruitment retention, changing working practices, well-being and mental health, or improving skills and performance. Only allowed 5 options on these things, so please do pick the one that sort of best represents what you think your top priority is. You can only select one, I'm afraid. And obviously I've got the results to hand from 2020 and 2021. So I thought it'd be useful just to see how sort of the priorities have changed, how maybe the employment market has changed. I'll give you a couple more seconds to sort of tick your answer, and then we'll have a look at the responses. Right, let's close that off now and have a look. Let's get that up. Yeah, hopefully you can see that. Someone shout at me if you can't. So yeah, so top priority, recruitment and retention, which I was kind of half expecting, because obviously there's been a lot in the press, sort of the Great Resignation, the difficulties in terms of recruiting people. So that answer was bottom last year, and it was second from bottom in 2020. So a real shift there into terms of that becoming a priority. The one that was top in the last 2 years was changing working practices. And obviously that's third from bottom now. So you obviously changed those working practices. They're all sorted. It's less of a priority for a lot of you now. But yeah, no, it's interesting to see that. We may do a sort of little article sort of highlighting those changes. So keep an eye out for that. Right, let's get back to what we're going to do. So let's get into some of the topics. So we're going to start off with talking about COVID. As I say, difficult time for many employers, and they had to make a lot of quite difficult decisions. And there's been an expectation there was going to be this sort of flood of litigation as a result. I don't know about a flood necessarily. The tribunal's quite slow as well, which doesn't help. But we're certainly starting to see some cases come through. So what we're going to have to do is look at those, see if there's any lessons we can sort of learn from them in terms of sort of future risks. I would say all of these cases we're going to look at in this section are what we'd call sort of first instance decisions. So they're employment tribunal decisions. They're not appeal decisions. So they're not binding, and they sort of very much change upon their facts. But they do at least give us some sort of guidance as how tribunals would approach similar cases in future. So first area I'm going to talk about is this protection that employees get if they have a reasonable belief that attending the workplace is going to place them at risk of a serious and imminent danger. They therefore don't attend the workplace as a result, and they can't be sort of reasonably expected to avert that danger themselves. And essentially, in those circumstances where you've got the employee staying away, so I'm not coming in, and they can establish they have this protection, then they have protection from dismissal and being treated less favourably or detrimental treatment as a result. And it's obviously quite a hot topic with COVID and people being concerned about the risks. And there are sort of three cases in particular at tribunal decision that have dealt with this. The first one is this Fortuna Group one. So this was exactly that, an employee who had concerns about attending the workplace, had concerns about the commute, wanted to be furloughed, which we'll talk about a bit later on, or wanted to work from home. The employer, in short, said no. You can have paid or unpaid leave, but you can't work from home, and furlough is not appropriate, we're too busy. And ultimately this employee, I think, requested furlough 3 times, I think, and ultimately was dismissed. Brought a claim, claiming automatically unfair dismissal because of this serious and imminent danger. That claim failed. Okay, and I'll talk about why the distinctions between these claims, but I'll just give you a brief overview to begin with. Second one is the Montenero case. This was an individual who was on holiday in Italy. Pandemic hits, lockdown. If he came back to the UK, he'd have had to do 14-day isolation at that time. Ultimately, at the time, he's told to sort of keep his mobile on, keep his laptop on, and then he's dismissed. And that claim was successful, again, on this serious and imminent danger point. And I'll explain why in a little bit, but that was a successful one. And then the Rogers one, employee sends a message to his manager saying, I'm staying away until COVID eases, or words to that effect, had some concerns about vulnerable children, and again, was ultimately dismissed there, brought a claim, and that claim was unsuccessful as well. So 1 successful, 2 unsuccessful. The reason for the different decisions is because they are all very fact specific, but there are some points we can sort of take out from it, and I've kind of highlighted these on the slide here. So First one is about what the employer has done. So have they carried out a health and safety risk assessment? Have they implemented what was required from that? Has that been communicated to employees, and has that then been enforced? Is it actually in practice? And one of the key decisions in that Rogers case was the employer had actually done everything that was required by the government at that time. And the tribunal took that into account in a factor in assessing whether or not the employee had this reasonable belief of a serious and imminent danger. And if you've done all those things, it will be much more difficult for the employee to establish they've got that concern. Second thing is just really sort of the general level of risk. As I say, the Rogers case is quite useful because it does establish that COVID alone doesn't establish a serious and imminent danger. Every case has to be sort of judged on its own facts. But there is an underlying piece here that most of these cases were quite early in the pandemic. And obviously the situation has changed somewhat since then. We've got the vaccination rollout. There appears to be an indication that the latest variant is less dangerous to certain groups. I know that's still developing, but it has to be judged at the time. And these cases are obviously a snapshot in time, so the decisions now might be slightly different. Particular risk to the employee, as I say, if the employee themselves is at a particular risk or their family are, then that's another factor that gets taken into account. The biggest one, I think, is probably the communication piece. And for example, in the Montenero one, where it was successful, the claim was successful, it was quite extreme almost. There was very little guidance given to the employee. They were under the impression that they were okay, or it was going to be okay for them to work remotely. There wasn't a direction about return. No warning was given. They were just sort of dismissed. And that is different from the other cases where there was a discussion or an attempted discussion about what the issues were. And then the final thing I would note that the tribunals have taken into account in these cases is about employer and employee conduct. So in the Rogers case, there was evidence there that the employee had sort of breached the self-isolation in his personal life. So he'd taken, I think, a friend to hospital. There's also some reference to working in a pub during the pandemic, which I can't work out whether that was at the same time or not. The judgment's not clear, but there's certainly evidence that despite these concerns about returning to the workplace, that wasn't reflected in how they were conducting their personal life. And in the Fortuna Group case, there was evidence there that the employee hadn't really explained what they thought the risk was, in particular at the workplace. So again, the conduct of the employee gets taken into account. But also the conduct of the employer. So in the successful case, the Montenero case, the employer dismissed the employee there by sending a letter to their London address, whilst knowing that the employee was in Italy. And I think it's fair to say that didn't go down particularly well with the tribunal. So a few things to remember on those types of cases. Looking at other sort of COVID lessons to learn, one of the other areas that's come up is your ability to sort of impose and discipline or dismiss employees if they fail to comply with your health and safety rules. This Kent Foods case is the sort of the key reported one, and this was in respect of a driver had to do deliveries to client premises, client sites. And they were ultimately dismissed for refusing to wear a mask in their cab of their lorry. Essentially, in very simple terms, turned up at client site with delivery. There was a rule on that site that you had to wear a mask. Repeatedly asked to do so, repeatedly refused to do so, saying it's not a legal obligation. And ultimately, that driver was dismissed. And their claim was unsuccessful. Now, at the time this was decided or came about, it was not mandatory to wear a mask. It was sort of optional, it's sort of guidance, but the client site that the driver was visiting had it as a mandatory requirement. So it's useful in a way. It does give evidence that restrictions over and above sort of what's required by government can still be enforced. You can still do that. You can have sort of more protections than is legally required necessarily. The reason this case is a little bit specific is that when you read the judgment, the tribunal places quite a lot of weight on the client relationship. So this driver had obligations to be courteous to clients, to take all reasonable steps to protect his and others' health and safety, and also to comply with client requirements on site, PPE requirements on site. And when you read the judgment, a lot of it is made on the fact that the client banned this individual from their site. And there was a lot of concern about that client relationship, in particular because the individual didn't accept he'd done anything wrong. So while it's a useful decision, there are sort of, so can't rely upon it too much. It is quite specific. And I think you still need to be careful with sort of members of staff with particular circumstances. So where they're saying they can't comply with something for a particular reason, maybe due to a medical condition or something of that nature. Two other areas I'll talk about in terms of sort of lessons learned from COVID. Clinically vulnerable, two cases to mention here. Both are quite extreme, I think it is fair to say. So the Prosser case was a pregnant woman who was sent home from work on health and safety grounds, basically said sort of stay away until such time as we put in place measures to keep you safe. Brought a discrimination claim amongst other things and was unsuccessful with that claim. But key to that decision was the employer had carried out a risk assessment. They did have genuine concerns about health and safety, and the individual was paid, I think, above and beyond sort of contractual rate while they were off. So that claim was unsuccessful. And then the Gibson case was about a chef who complained about health and safety in the premises, was concerned about their father, dismissed again, and was successful with a claim. The difficulty with this case is it wasn't defended by the employer. So it was decided solely on the facts and the evidence of the employee. They gave evidence that the employer, when raised these questions about health and safety, said words to the effect of shut up and just get on with it, which is not the recommended response, in case you hadn't guessed. So again, a difficult case to draw too much from because it is wasn't defended. So it wasn't too much of a testing of the arguments. What I would say, though, is it is quite clear that the tribunals in their decisions are more sympathetic to employees who do have medical conditions or their family do. Final thing, looking back on furlough. I'm not going to talk about this too much. Furlough schemes ended. No indication it's likely to return anytime soon. But the cases have made it clear that employees do not have a right to demand to be placed on furlough. It's very much an employer's decision. And the other case to mention is that Loving Angels case at the end of the slide there, which makes it clear that in a redundancy situation, employers should be considering furlough as an alternative to redundancy, but they are not obliged to put someone on furlough instead of making them redundant. It's a consideration point. But as I say, schemes close. If claims haven't already been issued, there's a good chance they might be out of time anyway. So let's move on. And let's look forward. And I've got another poll to sort of kick us off here about sort of vaccinations. So as normal, please vote when you're ready. But are you planning to treat vaccinated and unvaccinated workers differently in future? Yes, no, undecided are your options on this one. So the reason I'm talking about this has been in the press last couple of days, in fact, in terms of some employers taking decisions in respect of vaccinated staff or unvaccinated staff in terms of how they treat them. We've also got some changes ahead and have been brought in place in certain sectors. So let's have a look at your answers here, because it's only three things. Shouldn't take you too long to decide. Let's share the answers. So there we go. So the majority of you are no, which is telling me I shouldn't spend too long on this topic really, but there is a chunk of you that are still undecided. And it's interesting because what we've got is we've got sort of two sort of key developments, which I will take you through. The first bit is the decisions that some employers are taking, Next and IKEA, I think most famously, in terms of how they treat unvaccinated staff in respect of contractual sick pay. So what they are doing in broad terms, and I should add that I don't act for Next or IKEA, so I don't know all the details, but in broad terms, if someone who is unvaccinated has to isolate because of close contact with someone who does have COVID, they will not be receiving contractual sick pay, so they won't receive their full pay. That is different. So if someone who is vaccinated had to isolate, then they would receive their full pay. Now, there's two things to note there. One is we're talking about contractual pay, so not statutory sick pay, but that money is sort of full pay. And the other thing is that if an employee actually has COVID, the treatment is the same. And I would assume that they have gone on that, is that there's good public policy grounds as to why well, you don't necessarily want to be encouraging people who've got COVID to return to your workplace. So they've made this decision to not penalise, but certainly not treat as favourably unvaccinated employees. And if you are thinking about this, whether on sick pay and other things, there are a lot of it is a little bit tricky, so do take proper advice on it. But as a starting point, there are three broad things to really think about. One is the contractual position. So you need to check, for example, let's stick with the sick pay for the time being, that entitlement to sick pay, you need to check the contractual documents, sick pay policy, just to see if what you're doing is going to be in breach of those contractual arrangements. As part of that, you might also want to check what you've communicated to employees over COVID. Have you made a commitment that could be deemed a contractual term in terms of honouring sick pay in certain circumstances? That's probably unlikely, but still worth checking. But one is the contractual position. Second thing to think about, which I think Next and IKEA are doing, is about exceptions to any general rule. So if people have medical reasons why they're not vaccinated, if they have a particular religion or belief which means they're not vaccinated, again, that needs to be considered as well. Third key thing is around data. You will be collecting directly or indirectly information about people's vaccination status. You're going to need to make sure that you have documented what you're keeping, why you're keeping it, what your grounds for it are, how you're ensuring that you are only using it for certain purposes, that it is secure, and that's likely to be sort of special category data as far as the sort of data protection laws are concerned. So it's basically given additional protections. You're going to need to make sure your documentation and processes are properly in place. Leaving aside all of that, you've just got a wider piece. Obviously, we're talking about recruitment and retention being a key priority. You've got your general, just sort of, is this a good business decision? Is this really necessary? And with a lot of this stuff, there is a focus on being able to justify it. So why do you really need it in your sector? And are the disadvantages of imposing something outweighed by the advantages, which is just sort of the business rationale piece. Moving on, we'll only talk about it briefly, but you've got the requirements coming in particular sectors. So care homes were in from November, health and social care workers who have face-to-face contact from the 1st of April. Requirement there to be vaccinated. Obviously very sector specific, just be aware it is only for those particular sectors, doesn't necessarily give you carte blanche elsewhere. And the other thing I will talk about focusing on COVID looking forward is you've got some temporary changes to the statutory sick pay regulations, which hopefully you've already picked up because it came in December. Runs through until the 26th of January, but in simple terms, employees don't have to get a GP note until after 28 days of absence. Right, let's move away from COVID because we've got lots of other things to talk about. Flexible working. Say we're moving away from COVID, it is still a little bit like that, but what are your plans for your business when COVID restrictions have been removed? So this again is very broad brush, but try and pick the one that best represents your position. Appreciate it may be dependent upon roles and things of that nature, but giving you 5 options: 100% remote, hybrid working where you are enforcing that, so you are placing requirements on the employees where they are at certain times. Hybrid working if the employee elects to do so, so they could be 100% office based, it could be 100% home based, maybe it's all up to them. Occasional remote working only, so sort of emergencies or ad hoc, and then 100% workplace office based. Appreciate that probably isn't very nuanced, but it's interesting to get a little bit idea of where you all stand. Right, let's get those results up. There we go. So quite a lot of you, if we pull together the 2 hybrid working elements, with certainly the majority there having something like that. Not that many at the sort of the 2 extremes, but some there. Obviously, some of that's going to be sector specific as well. But obviously, flexible working is hot topic. A number of cases last year, some of them quite high profile in the press. And these cases in particular concern indirect sex discrimination. So in very simple terms, indirect sex discrimination arises where you have a provision, criteria, or practice that applies to everyone. That practice puts a particular group with a certain protected characteristic at a disadvantage. It also places the individual who's bringing the claim at a disadvantage, and the employer isn't able to establish that they can justify that practice. So is it a proportionate means of achieving a legitimate aim? And these cases, there's 2 bits I'm going to look at. First bit, I am going to look at this idea of group disadvantage. Is it still the case that it is accepted that women are more likely to be adversely impacted by a requirement to work full time because of childcare commitments? Is that still the case now? Things have obviously moved on a little bit. And then the second one is about justification and how employers are able to justify decisions, and a couple of occasions where they failed to do so. So the first one, which is this FT headline down in the bottom corner there, is about this group disadvantage. And in short, what the Employment Appeal Tribunal decided there is that the childcare disparity between men and women is something which courts and tribunals need to have judicial notice of. And what that means in quite simple terms, judicial notice is something that is so accepted that there isn't a requirement for evidence on it. It's something that the tribunal can draw of its own conclusions. Now, that doesn't necessarily mean that every case will win, but what it does mean is despite any cultural shift-ins, the fact that men may have more childcare responsibilities than they used to, there is still sufficient evidence that it is kind of taken as read that women are more likely to be disadvantaged by sort of full-time working requirements. So that's one piece. The other piece is a couple of high-profile cases where the employer has failed to justify their refusal of flexible working requests. The estate agent one is Alice Thompson, who instead of working 9 to 6, 5 days a week, wanted to work 9 to 5, 4 days a week, and was successful with the claim. And there are 4 key reasons why the employer failed, I would suggest, when you read the judgment with that, which is good learning points for us all. One is that they didn't really set out their reasons why the working arrangement she was asking for wouldn't work. There's a suggestion that there were some factors they were considering that they didn't properly reflect in the paperwork. There was a suggestion that the revised working arrangements would require a change in the commission structure, and the tribunal said that's not a reason to refuse the request. Not insurmountable, I think, were their words. Quite key, I think, is there were existing staff. So the employer had looked at whether or not they could recruit someone to cover these other hours, which they probably quite reasonably said they couldn't, but there were existing staff who could step up. And also, which is a factor in the other case, is they didn't consider any alternatives to the proposed working changes. Second one there is the BA City Flyer case. Again, another successful indirect sex discrimination case. 4 key reasons I would pull out from that as to why the employer struggled there. One is that they didn't properly consider the request. So going through process was very much a tick box exercise, and that was noted by the tribunal. They didn't ask any questions. They didn't properly talk to the employee about it. They made an assumption about employees' other willingness to cover. So instead of actually asking them, they were making assumptions that they wouldn't be willing to do it. And they also gave some rather poor evidence on the day of the tribunal, in which they indicated that any impact on the business would give them grounds to turn it down, whereas actually that doesn't work legally. You need to balance up the requirements of the individual against the business. And then the other thing there, which is common with those of them, is they didn't consider any alternatives. And that really is quite important, because if there is an alternative you can propose, it will help give you a much better defense to these claims, because A, it will show you've considered it properly, and B, you'll be justifying a policy that isn't necessarily just full-time, 9 to 5 or 9 to 6 in the estate agent case. So just quickly on flexible working, the risks. There is a formal process, so we're doing a specific session on flexible working in February, which I'll talk about at the end. So if you want full details, that's the place to get that. It's very much just an overview. But there is a formal process you may need to follow for people with 26 weeks service. If you get that wrong, that can be worth 8 weeks pay. Be aware of discrimination claims. That could be the indirect sex discrimination claim we're looking at, but also think about disability, religion and belief. If there are particular reasons why people need a certain working pattern, then take that into account. The other one to watch we sometimes see is age cases. Only senior employees can work flexibly. Just think if there's an age angle there. Constructive dismissal claims can arise if you haven't acted reasonably or reached a fair decision. And for all you people with your hybrid working, one area we're expecting to see developments is even when you've put that in place, we're seeing sort of reports around sort of proximity bias. So giving employees the option as to where they work, but then treating those who are present in the office more favorably than those who are choosing to work from home. And there's this idea of proximity bias. There's lots you can read about it, sort of unconsciously preferring those people who are closer to you. And if you've got a disparity, and it's mainly women working at home, mainly men in the office, you could end up with discrimination claims as a result of that as well. So even when you've got your hybrid working set up, that may not be the end of it. And then the final thing I will flag is there are some changes in the pipeline for this. We'll talk about this more in February. But called a consultation called Making Flexible Working the Default. That's not actually what it is. They're looking to sort of rebalance it. It's not going to be automatic flexible working, or it doesn't look like it, but they are talking about making it a day one right, so not having to wait for that length of service before you request flexible working. Some changes to the process and some potential changes to the reasons for rejecting decisions. Maybe a proactive requirement to suggest alternatives. As I say, if there is something you can offer, that's a good thing to do anyway, but that may become more of a requirement. And also a stress that temporary arrangements can be accommodated, which they can under the existing rules, but I think there's a feeling that that's not well enough known. Right, whistle stop, flexible working. Next up is sexual harassment. It's another hot topic over the last year. I'm going to ask you a question here. See if you know the answer. So as always, just vote when you're ready. What percentage of the UK population has experienced sexual harassment in the last 12 months? Now, this is from a government survey. So there may well be surveys with different answers, but that's what I've used for this. 22%, 29%, 43%, or 72%. And this is the entire UK population, so men, women, all different protected characteristics. What percentage have experienced sexual harassment in the last 12 months? Right, I'm going to close it off. See how well you all did. So the correct answer is 43%. So 43% have experienced sexual harassment in the last 12 months. Those of you who said 29% are, a majority of you said that, or most of you, you're not, well, you are wrong, or at least you're wrong in respect to this survey. But that was the figure for in a workplace. So it was 29%. So the 43% is harassment anywhere, but it was 29% of it experienced it in the workplace in the last 12 months. So nearly a third, which is yeah, quite worrying really. And the 72% figure, that was in lifetime. So percentage that have experienced at some point in their lifetime. So quite a big issue, and frankly, not just for legal reasons, or indeed moral reasons, it's a big issue. The business disruption that this can cause, whether it's reputational, whether it's customer relations, whether it's recruitment and retention, as we were talking about earlier on, whether it's your share price, whatever it is, the impact of these sort of allegations coming to light is huge. And we've got some proposals for reform here. These are probably one step further on than the flexible working ones. All of this stuff is meant to be coming in via an employment bill, which we expect to be published this year, which will have more details around all of these things. But what it's looking to do is introduce a new duty to prevent sexual harassment in the workplace. Now, the claims relating to that will only be allowed to be pursued once an incident has occurred. So you can't sort of, employees won't be able to proactively bring a claim before anything has happened saying you're not doing enough. It'll be once something has happened, the legal claim will trigger. And there's going to be this sort of all reasonable steps defense. So basically, if the employer can establish they've taken all reasonable steps to stop sexual harassment taking place, then they would have a defense to a claim. Now, it's a bit of a question mark as to how much of a change, how much this will add on to the existing legislation. It depends, really. We need to see the details in the employment bill, but it certainly is probably going to encourage claims, and it is probably going to extend the obligations on employers further. We just need to wait and see how much, really. The big potential change is the second one there, third-party harassment. So it's potentially making employers liable for harassment that's committed by third parties, unless, again, they can establish as all reasonable steps defense. Now, that is a big change if they bring that in, because at the moment, it is very difficult to bring a claim as an employee against an employer saying you didn't prevent this third party from harassing me, whether it's a customer, supplier, whatever it might be. So that would be a big change. Confidentiality clauses are being looked at, NDAs as they often call them. So that's commonly in employment contract settlement agreements. Do they need to be limited further to make sure that these issues are being reported? There's going to be a new statutory code of conduct which will tie in with those new duties to prevent sexual harassment, which ideally will give some further guidance as to what this all actually means. And they are looking at extending the time limit, not just for sexual harassment claims, but all discrimination claims out to 6 months. Now, those are sort of the proposals. What do you need to be thinking about? So these are the types of things we would suggest you should be thinking about, regardless, really, because it's best practice now, but they will become even more important, or indeed crucial, as and when these changes come in. So I'll run through these. First thing I would say is just sort of understanding the extent of the issue. So it is well known that sexual harassment is often not reported, and therefore there's often a lack of awareness as to how often it is occurring in an organization. Management needs to be aware that that is likely, that it may not be reported. There needs to be an attitude of it could happen here, and therefore steps being taken to make sure it doesn't. One of the suggestions I've seen on this is to think about exit interviews. People may be willing to be more open on exit interviews in terms of any issues. This also ties in with reporting, which I'll talk about a bit later. Trying to establish a culture of zero tolerance. Lots of things obviously feed into that. It's about building a culture, somewhat unsurprisingly, but certainly top level management buying in and communicating your policies and approach to it, making sure it's all actioned. And effective policies, well, you could talk about that for an hour in itself, but you need to be ensuring that they're covering all of your staff, so not necessarily just your employees, but think about your workers, your contractors, your agency workers, setting expectations, being clear on consequences. Relevant examples as well is quite important. So thinking about particular risks in your organization. So for example, if you are a call center, the chance of verbal abuse on the phone is going to be very high. You know, working in a pub, there may be other risks. It depends, but think about it. Think about your policy tying in with that. Reporting, we will talk about, but you want to really be encouraging reporting, not just from victims, but from observers. Making sure that any aggravating factors are listed in there. So if there's an abuse of power, make sure that that's covered off. Removing time limits for reporting, highlighting any support that's available internally or externally for employees, and then regularly reviewing it and checking the effectiveness of it, which is difficult, but you can think about staff surveys, things of that nature to check that there's awareness, what do people think about it, what's happening in the organization. Reporting mechanisms, 2 points there really is think about should be lots of different people they can potentially go to and lots of different ways they can do it. So some people will be happy to talk about it verbally or face-to-face, others might want to do it online. Think about confidential reporting. Makes it more difficult sometimes to take action on the specific scenario, but might give you an insight into what's happening in the organization so you can take wider steps. Training, make sure it's tailored. As I say, focus on the risks in your business because there may be some specific ones. Case last year on discrimination training, which this equally applies to really, is making sure that training isn't stale, it's not a tick box exercise, it's actually engaging people. Workplace champions is a suggestion. That's really about having people who have the experience and have the training to support individuals who are bringing a complaint. And then suppliers and customers, that's going to be crucial as and when we get this third party risk come in, this third party harassment risk. Good practice already, but think about tying them into your policies via the contracts. Think about public notices. How are you going to ensure that those other parties your employees come in contact with are acting appropriately? And then the final one is settlement agreements are sometimes considered a way of brushing this under the carpet. Think about your sign-off mechanism there. Right, I've got a few final things to run through and then I need to try and hand over to Imelda roughly on time. So I've talked about this employment bill. We are expecting that should really be some point this year. Obviously a fair bit of political uncertainty at the moment, which I'm not going to comment on, apart from the fact to say if there is a change in leadership, you never know what the priorities shift to. This is meant to be being brought forward as soon as parliamentary time allows, but you know, people prioritize different things. Few things to watch out for here. Plan to be a single labour market enforcement body with proper resourcing. Tips and service charges, some changes there to make sure that is all going to the worker and there being more transparency about that. Right to request a more predictable contract, which has been bouncing around for years, but in theory, once after 26 weeks, if you don't have set hours, you might have the ability to request more fixed hours. Women on maternity leave have additional protection from redundancy, as many of you will know. Let's talk about extending that, so it extends out for 6 months after they return to work, which I think will come. It's just a question of when they actually do it. Statutory paid leave for parents with babies in neonatal care. That's looking like it will be 12 weeks paid leave. And then 1 week's unpaid carers leave. That is meant to be for employees who have dependents who require long-term care. And that can be for a whole range of things. It could be personal support, taking them to appointments, and it's likely that that's going to be flexible. So it might be half days, a day, taking it as a block, etc. Final things I will just mention. We've got an additional bank holiday this year because of the Queen's, is it Platinum Jubilee? I think it is. You can correct me in the questions if I'm wrong, but an extra day and one of the bank holidays is shifted. I think it's probably fair to say that most employers will honour that additional bank holiday, but if you don't want to, you need to check your contracts to just see whether you've got a contractual obligation to do so. even if you don't want to, will depend upon the wording. And just watch out for part-time staff and make sure they're not being less favourably treated on a pro rata basis. There's an extra day there. Post-termination non-compete clauses, government did a consultation on it, closed in February. I haven't heard anything since, but in theory that could come to life again. They were looking at whether or not they needed to ban them or do something to limit them. Menopausal rights. In short, I would say check out the excellent roundtable webinar my colleagues did on this last year. It's on the website. It's excellent. It's a hot topic. We're seeing more and more inquiries about it. So it is one to be well abreast of and be aware of sort of employer responsibilities there. And then the final thing, we've obviously got the normal sort of rate changes in April, which I won't list here, but national minimum wage, maternity pay, etc., all go up in April. That's easily found online, but just something to watch. Right. Enough employment law for now, although happy to take questions later, so get typing them in if I've gone over to anything too quickly, and I will hand over to Imelda.
Thank you, Ian. Wow, you've covered so much. I hope you guys will stick around for the next 30 minutes to see what immigration has to offer. Okay, straight into my topic. So I'm going to look at 5 topics. I'm going to look at the new immigration points-based system, have a look at some of the new visa routes that are promised for this year, very exciting routes to come, some of the latest immigration rule changes towards the end of last year, more right to work changes from April 22, I'm afraid. And then finally, I will look at some of the reforms to the sponsorship IT system, which will be most welcome from existing sponsors. Now, just to get you involved, I'm moving straight into my first poll. Can you put the poll up, Ian? Thank you. Okay, it's just really to give me an idea of my audience. So if you are currently a sponsor, when did you register for your license? You have 4 options. Either you're not a sponsor, you don't remember, it was 2020 or later, or it was before 2020. I'll give you a couple of minutes. Okay, I think, Ian, maybe we can show the results. Oh, wow, 69% of you are not a sponsor. 4 don't remember, 8% registered in the new system, and 18% registered before the new system. Okay, that's very interesting to know. So for those of you who are not sponsors, which is the vast majority of the audience, I'm afraid, there may be some terminology that I'm using that you may not be familiar with, but please do add questions and I will do my best to answer as many as I can. Okay, move to the next slide, please, Ian. So let's straight into the new immigration system. It has been in operation since just over a year, since December 2020, and it was really designed to support the departure from the European Union. It has been the biggest shift in immigration policy in recent history, and 12 months on, the Home Office believe that it has delivered on the public priorities and with the aim to attract top talent from across the globe, whilst encouraging businesses to invest in the British workforce. So the biggest single edition of the new points-based system, which is going to affect those of you who want to recruit from the UK and overseas, was the skilled worker visa route. For those of you who are familiar with the sponsorship system, this replaced the Tier 2 general route. And there's some key changes, which effectively makes the route more accessible to a wider range of occupations. So the first point is that the skill level was reduced to A level, which was previously sitting at a degree level. The minimum salary has been reduced to 25,600, whereas it used to sit at 30,000. And there's a removal of the mandatory resident labour market test, which has reduced many, many hours of recruitment processing, usually for an employee who had already been selected. It has opened up access to many occupations which are lower levels. So some examples of these are butchers, bricklayers, and senior care workers. Additionally, we have new visa routes which are part of the new points-based system. I'll cover those in summary a little bit later. And glad to see there are some reforms to the existing sponsorship system. Move to the next slide. So let's look at some of the sponsorship reforms. The focus of the Home Office is to make some major reforms to the existing sponsorship system, which has been around since 2008. So effectively, it hasn't been updated since that time. It's rather clunky, rather difficult to operate, and very, very difficult to report on. The Home Office understands that the sponsorship system is perceived to have barriers because of the difficulty in operating, the number of elements in relation to the guidance and the links to operating the sponsorship system, and the time it takes either to review the guidance and then process the applications. So their intention was to make reforms that would improve the user experience for both the employers and the employees. So the first point is to speed up the process. Currently, it takes 8 weeks to process a license application, and there is an expedited service which can offer a 10 working day service. However, at the moment, there are only 10 slots available for the entire country, and these are notoriously difficult to operate. For those of you who obtained a license prior to 2020, this took much longer with the mandatory resident labour market test in place, which would add at least 4 weeks to the application and sponsorship process. So we have seen a reduced timescale in terms of processing, which is currently sitting at 8 weeks. They also want to improve the experience of users. So the Home Office have taken some time to undertake research, particularly with smaller businesses, to see how they could approach the system and use the system without too much support from representatives or from other third parties. They also intended to review the fees and look at how skilled workers could identify whether they're actually eligible for utilising sponsorship. And in the improvement of experience, they did, as I say, invest some resources into creating documents. I will look at these a little bit later. In terms of the review of the sponsorship fees, they agreed that these are actually about right in comparison to other countries who offer similar systems. And they have, in fact, released an eligibility tool, which is very easy to use. And I will send you a link. We will look at a link a little bit later in one of my slides on the presentation. And finally, the reforms were to prevent abuse. Unfortunately, under sponsorship, there was a lot of abuse. There were organisations who would create roles effectively to fill with a migrant that was potentially in employment, or just to bring somebody across from overseas. And although they would claim to pay an element of salary to the Home Office, they would often not pay that amount to the worker, making all sorts of deductions. So in order to prevent abuse, the Home Office have instigated a pilot programme with a salary check feature with the Home Office. So this effectively will look at the information that a sponsor reports to the Home Office on that certificate for that particular worker, and ensures that once the HMRC records, so your real-time transmissions submitted with your salary reports on a monthly basis or weekly basis, are in line with what you have reported to the Home Office. And that report also looks at any deductions. So you are also required to report any deductions to the Home Office in addition to any salary. So I have not had a sponsor come back to me to say I have been selected and questioned about the salary differences being reported on the Home Office system and the HMRC, but I expect that these are yet to come. So these reforms were actually put in place by the end of last year, and we will look at how they have impacted the system in a few moments by showing you some of the documents and the systems that they have created. So the first one is the Employer's Guide on the New Immigration System. I have a link to this document, which is about 16 pages. This is a very, very useful document for the 69% of you who are not yet sponsors. Go away, have a look at the link. If you do want to consider sponsorship or recruiting migrants from within the UK or overseas, it's a very simple guide. establishing a more streamlined approach to sponsorship. It gives you an overview of the new points-based system, the work routes. It guides you to the eligibility checking tool for candidates. It contains all the links to the sponsor license requirements, the evidence, the duties, and it also covers a little bit about right to work checks, highlighting the changes for European nationals from July and the deferral of the adjusted checks for COVID, which will change from the 6th of April 2022. And I've also included a link to the employer's partner pack, which is similar lines to the employer guide, but a much wider package of links, diagrams, flow charts. So this again is a really good start if you are considering applying for sponsorship at the Home Office. So I'm now going to look at some of the new visa routes which are included in the new points-based system. The first one isn't a new route, but it does add a couple of new countries to the scheme from this year. This is called the Youth Mobility Scheme. It enables young people to experience life in the UK for up to 2 years. For those adults under the age of 30, they can live and work in the UK without the need for an employer or a sponsor. Before this year, there were 9 countries who operated, with India and Iceland been added from January 2022. Applicants to the scheme are required to show an element of savings so that they won't rely on public funds when they come to the UK, and they cannot be financially responsible for dependents. Now, different countries operate different schemes, but the Home Office allocate a number of places to each country, with Australia being the largest at 30,000 places. These places are normally allocated at 2 points in the year, namely January and July, and it gives the applicants an opportunity to make applications on both of these occasions. Some countries operate a ballot process, and India is one of those countries who will operate this process from January. We have been inundated with inquiries from Indian nationals about the ballot process. The Home Office, unfortunately, have been delayed in making the ballot available, and we're checking daily to see when this will open. It means that Indian nationals who want to come to the UK under the scheme will have to apply for a lottery effectively, and once they have acknowledgement of the lottery, will then have a very short period to make an application for the actual visa. The next new visa route, exciting visa route that has come into operation this year, is a scale-up visa route. Now, this was part of the innovation strategy which was published last summer, when we were promised a number of visa routes to attract top global talent to the UK, in addition to the sponsored routes. So primarily this is an unsponsored route, and it's designed for highly skilled and the academically elite. There is a requirement to have a job offer from a recognised UK scale-up company. There will be a minimum skill level to the role. We're not quite sure where that will be. It'll either be similar to the skilled worker route, or perhaps a little bit higher to distinguish it from the skilled worker route. There will be an English language requirement, which may cause issues for European nationals who don't necessarily have an English language proficiency level or a degree taught through English. So that may cause additional time to process this new certificate. There will be a minimum salary of 33,000, slightly higher than the skilled worker route, again, probably to distinguish the additional skill. And at the moment, we haven't yet had a proper definition, but some of the endorsing bodies have said that a scale-up company could be defined as a company which has high growth of 20% or more for a year on year for at least 2 years, have a minimum of 10 employees. And these endorsing bodies estimate there are approximately 34,000 in the UK currently. So there will be lots of opportunities for potentially the companies who don't want to sponsor or register for sponsorship to utilise this visa route to bring people into the UK. My next new visa route, or the next new visa route, which the Home Office will bring into force this year, is the high potential visa route. Oh, actually, Ian, I forgot my poll. I'm sorry. Right. What 2 countries can apply for the Youth Mobility Scheme from 2022? I just covered it in an earlier slide, so I hope you remember. You have 4 choices. Is it India and China? Is it India and Russia? India and Iceland, or China and Russia. Hopefully this will be rather quick. How are we doing, Ian? Do we have a full poll yet? Oh, well done. So yes, 63% of you are listening. Thank you for your participation. Okay, we'll move back to the high potential visa. Again, this was discussed in the UK Innovation Strategy last summer, with an attempt to have a selection of visas that would attract talent to the UK. And really, it was following the exit from Europe, the government realised that we needed to encourage European nationals who wouldn't necessarily have a right to work in the UK with some visa options that would give them choice to move around, as opposed to being linked to one sponsor. So this high potential visa is geared towards individuals who have graduated from a top global university. Again, we have been inundated with requests from numerous nationals about how they establish where the graduation is from. And unfortunately, the Home Office have given us very little guidance on what is considered a top global university. So the guidance is still not finalised, so we don't yet know. But we hope it's going to include more than the Sorbonnes and the Cambridges and the Harvards of this world. There is no requirement to have a job offer, so these candidates can come to the UK and look for a role. Again, no sponsorship. And this route actually will lead to settlement after a period of 5 years. We don't yet know if that will be in one go or if they'll be required to do it in an extension 3 and 2 years, like most other routes into the UK. So again, another very exciting visa route, which we hope to see later this year. And we move to the final visa, which the Home Office will introduce this year. This is called the Global Mobility Visa. And this is based really on some of the existing routes, mainly the intercompany route. But it also has aspects of the overseas representative route. There are also some of the temporary worker routes under the old Tier 5 scheme. There are also little elements of what would be permitted under the visit visa route for companies with an overseas branch. So really, it's going to be a little bit of a compilation of lots of visa routes that exist at the moment, all under one banner. Since Brexit, it has been exceptionally difficult for organisations who don't necessarily want their staff from an overseas, from a particular European branch to work full-time in the UK or to operate under a visa. So at the moment, they're relying on using some of the permitted activities under a visit visa, which is very, very difficult for those who need to travel regularly to the UK. So it is hoped that this global mobility visa route would cater for organisations who currently have operations in Europe and a contract with some form of organisation in the UK. So what we're seeing at the moment, and again, the guidance isn't fully decided, we are expecting that the route will only permit those who have an existing relationship or they're an employee of the business overseas. And from what we know at the moment, it'll come under 5 specific categories. So the worker would need to be a senior or specialist worker, which really falls in line with the intercompany route that exists at the moment for senior managers, or a graduate trainee, again in line with the intercompany route for graduate trainees. A UK expansion worker, which could fall under someone who is a representative and wants to establish a branch in the UK. Secondment worker, again, which falls under the business visit routes for intercompany activities, or a service supplier who is providing a service to a UK organisation. We initially thought this route would operate for would allow companies not to register for a license, but we're seeing at the moment the limited guidance that's available that the UK businesses receiving the workers will need a sponsor license, unfortunately. We expect the jobs will be at a skill level of level 3 or above, don't quite know, that could go as high as the intercompany, which is the degree level or level 6. There will be a salary threshold, probably a little bit higher than the skilled worker route, but again, we don't quite know the details. Workers must be in an existing relationship or have a minimum length of services overseas, which falls in line with the intercompany route of 12 months at the moment. We expect the assignments are expected to be temporary but flexible. So coming in, they will not be in a route to settlement, but those workers can switch if the employer or the arrangement decides that they need to stay on in the UK more permanently. And for the moment, we don't expect to have any English language requirement. So particularly for European workers who don't necessarily have a degree in English or another language proficiency certificate, it'll certainly make the process a little bit easier. Now, some more information on the global mobility visa route. It will be available to businesses with or without a UK presence. So an example would be an overseas parent company sending a worker to the UK to a branch or subsidiary, a service supplier sending a worker to the UK, a purchaser sending a worker to a UK supplier, or a business sending a worker pre-trading to a UK branch. So there are lots of options for workers to come into the UK. Again, the registered license holder must be operable in the UK for receiving a worker into the UK on a visa. As with all visa routes to the UK, there's an element of demonstrating evidence. So if you are claiming that there is a business relationship, you will be expected to provide some contractual documents or some form of common ownership or provision of goods or services or UK expansion in addition to the visa application. So I'll move on to my next topic of the immigration rule changes. There are a couple of these that were reported just at the end of last year. Some may apply to you, some may not. The first one may affect those of you who are welcoming European nationals or Swiss nationals. So ID cards are not permitted for entry into the UK unless the European national or Swiss national has status under the European Settlement Scheme. So European nationals now must present a passport on entry to the UK. There are still some COVID concessions in place. Namely for a route called the Tier 1 Entrepreneur route, which is a business route for an entrepreneur to set up an organisation in the UK with the hope of having 2 full-time employees before they're ready to settle here permanently. There is a concession for those who have not been able to demonstrate those 2 full-time roles by the time it comes for their extension. To be able to further extend their visa until such time as they can show they have extended their business and supported 2 full-time employees. For European Settlement Scheme applicants, where there are excessive absences due to COVID, those applying for settled status under the European Settlement Scheme will be able to demonstrate those absences as a result of COVID, and hopefully will not affect the absences in terms of obtaining settled status. Similarly, for skilled worker and Tier 2 sports persons, those who have had to spend excessive time in waiting for a decision, they can add that time when it comes to calculating their residence period for settlement after 5 continuous years in the UK. And 2 more updates on the immigration rule changes is the international sports person. This sat in 2 separate visa routes in the past, so they have been combined to have 1 international sports person route from Tier 2 and Tier 5. There will still be the element of the sports governing body endorsing the sports person, and a certificate of sponsorship from the club would still be required. But there is a major change here that English language proficiency will be needed for those who want a visa for over 12 months. And the Global Talent Route, which has been in operation for over a year, they are looking at introducing some additional criteria to cover cultural endorsement. There are also some new evidential requirements in terms of digital technology, and the prestigious prizes list has been expanded to include 70 further eligible prizes. Again, we get lots of inquiries about this, just as an example of the prizes that have been included, we have things like the Booker Prize, the Olivier or Mobos. So there are lots of prestigious prizes which will be accepted if that candidate can demonstrate, including additional criteria. So that concludes the immigration changes. I'm going to move on to right to work checks. Hopefully this will be the last change of right to work checks. Those of you on at the moment, I'm sure, are all operating the adjusted checks as a result of COVID. These will operate up till the 5th of April. The slide covers what the checks you should be undertaking at the moment, but I'm really conscious of time, so I'm not going to read through the information. But as they finish on the 5th of April, just ensure that you have undertaken checks accordingly with the appropriate markings on the paperwork, etc. But we will have changes from the 6th. So the removal of the adjusted checks will happen from the 6th of April. And at this point, employers will only be able to use in-person checks where permitted and use the employer checking service where necessary. So from the 6th of April, also, employers cannot accept or review physical documents as a valid check for biometric residence card holders, biometric residence permit holders, or frontier worker permit holders. So please note that only online right to work checks will be valid from the 6th of April. There is no need to do any retrospective checks for holders of these, and please bear in mind that most of your visa nationals will be holders of one of these documents. Employers will continue to maintain a statutory excuse against a civil penalty if the checks are undertaken in line with the relevant guidance at the time. And one final introduction from the 6th of April, which will be news to many people, is there is now the introduction of an identity service provider to carry out checks for British and Irish nationals. This also falls in line with the checks for criminal record checks, DBS checks, etc. If you want more information about this, this has just literally been released in the last day. I can provide you with this, but it also aligns with the element of non-discrimination against workers who are coming on board. You request right to work evidence from all workers, including your British and Irish citizens. Moving on to what's new in the, what's new, what's coming. I've taken a couple of points which I think may be relevant for the audience, or maybe not as quite a few aren't sponsors, but my apologies. There is one addition which I think will be useful for some sponsors. It was reported just at the end of last year that there is a drastic shortage of carers, and there is a proposal for carers to be added to the shortage occupation with immediate effect. Currently, the only carers eligible for a skilled worker visa are senior carers. So we expect to see in the coming weeks as to whether the Home Office have accepted these proposals from the Migration Advisory Committee. So if you are responsible for employing carers or senior carers, watch this space and I will inform you as soon as we have any more information. We also have a new right to work guide, which was published on the 17th of January. The link is there. It mainly updates the changes that will come into effect from the 6th of April, including the removal of the adjusted checks from COVID, the introduction of the checks for British and Irish nationals, the digital checks, and the new checks for those who are visa holders, where they will only accept an online check. And finally, from the end of December, applicants in the UK can apply for visas using the ID app. This is a real welcome change. It was originally only available for certain visa routes, but it avoids applicants having to attend visa centres and saves lots of fees in terms of those appointments. And once an applicant obtains status using the ID app, they will have an e-visa. This is an electronic status. There is no physical documents. So hopefully for employers, these will all be online checks, and there will be no need then to view physical documents from these new workers. And my final topic is sponsorship performance for IT. I know at the outset there are very few of you on who are sponsors, but there is a good possibility that you may need to obtain sponsorship in the future. the Home Office are planning to invest heavily in their IT system to speed up the process, to reduce the administrative overhead for sponsoring employees, and they intend to have a single online dashboard which ties in with using information that they already have from other government resources, so from Companies House, from HMRC, from any other resources that share information. And will also allow employers to check the statuses of their license, whereas currently they submit it and wait 10 weeks, 8 to 10 weeks until Home Office have a decision. They're also hoping for sponsors who have already had years of compliance not to have to wait the same 8 weeks as a new sponsor. And hopefully by the middle of this year, the Home Office intend to pre-populate the visa application with the information we provided on the Home Office SMS system. By the end of 22, the system should be able to provide sponsors with reports so that they can view the workers. Currently, you can view one worker at a time, which is ludicrous. So sponsors and employers are having reports in diaries and spreadsheets. It's all over the place. So we don't yet know what it'll look like, but it has to be better than what exists at the moment. And then by early 23, there will be automated data checks to speed up the license process. Again, this is designed at looking at information that exists in the public domain and not necessarily a request and duplicate information. So that concludes my, my update. And now we will open the floor to questions.
That's great. Thanks very much, Imelda. That's really useful. I'll open up the question box in a minute, and we'll see as many as we can get through in the time. A few things I'll flag before we jump into that. As you can probably tell by the speed we've whipped through a few things there. Obviously, do take proper legal advice on your own circumstances. After the questions, just a reminder, we've got that feedback form. Brilliant if you can do that and stick around for that bit and give us that feedback. It also gives you the ability to sign up for the various different updates and content throughout the year. So there's quite a few things that both me and Imelda have talked about where there are still some uncertainties, details to come. We will be reporting on those throughout the year. There'll probably be further webinars and events on them as well. So if you want details of those, you can sign up via the feedback form or just email us. And then I mentioned flexible working. Colleague David Clay is running an webinar 8th of February, so date for your diaries there, and he'll deal with that flexible working side in a lot more detail than I've had time to today. But let me get this question box open and have a look. Oh, right, we've got quite a few. Right, where should we start? I should just pick out the ones for Imelda, really, shouldn't I?
Oh, thank you, William.
Sit back. Right, let's have a look. Oh, here's a good one. Let's start with one for you, Imelda.
Okay.
What is the current success rate for being approved for sponsorship? So for the license, I assume.
Well, I don't have any public information, but all of the licenses I have submitted have been approved. Most, in fact, all within the 8-week timeline. And just the end of last year, I had managed to get a few through on the priority service as well. So I think if in doubt that you don't meet the requirements or you haven't read the guidance sufficiently enough, it's worth just getting me or another advisor to double check your application. But as I say, I have been successful with all of them. I haven't had a rejection.
Well, that's good to hear.
So far, so good.
Yeah, things good. A global business mobility visa. Would an agency agreement signed by both parties serve as evidence of relationship between separate companies?
The real answer is I don't yet know. It hasn't been tested. The route is not operational at the moment. We hope that there will be some flexibility because there is a lot of pressure to have something in place for organisations who could move people pretty flexibly before we left Europe. So the answer is I don't know. But if I compare the intercompany route, I have been able to demonstrate a worker who has been provided a service to that entity overseas to bring them in under the intercompany route. So if that helps in terms of giving you an idea as to what you might need to demonstrate, then so it's possible.
Yeah, no, good. Shall I answer some for me now? Give you a bit of a break. Does the day one right to request flexible working, does that exist now, or was part of the pending new bill? That is pending. So currently you need 26 weeks to make the formal flexible working request. One word of caution, though, is that some of those other claims, like when we're talking about those indirect sex discrimination claims, you don't need any length of service for those. So even if you are getting a request in and someone doesn't have the 26-week service, you still need to be a bit cautious that you can justify what you're doing. So yeah, hopefully that answers the question. But yeah, that is the day one right is pending. That is in the well, we're anticipating that's going to be in the employment bill later this year. Question on long COVID. Yeah, interested in the current situation on that. Maybe affects a number of employees and prognosis is uncertain. I think you're right. To be honest, the prognosis is uncertain. There's probably not too much more I can add to it, apart from to say that currently the key thing is whether or not those individuals qualify as disabled under the Equality Act. So it's the normal test. So it's looking at, is there a substantial adverse impact on their day-to-day activities? Has it lasted, or is it likely to last for 12 months? Those types of questions. So the difficulty you have with it is normally the answer is we'd say go off and get medical evidence, which probably still is the answer. But getting reliable medical evidence is somewhat more difficult because obviously there is still some medical uncertainty on the prognosis. Obviously one to take advice on the specific circumstances, but it's probably one where you would err on the side of caution. So you would, if in doubt, you'd probably assume they were disabled, and you'd look at reasonable adjustments and all the other things that you would do normally, and then go through your due process. There would be some risk involved in just assuming it's not. Relocation question for me. Many employees have relocated further away from the office in the last 2 years. Contractually office based, how can we reasonably ask someone who lives 200 miles away to come back to the office 3 days a week? Well, the contract point is a good starting point. So are they contractually obliged to potentially be in the office, let's say 5 days a week? So you need to check the contract situation, check their contract, check what's being communicated with them. Assuming you've got the right to require them to come in, the only things you then need to be careful about are acting reasonably so you don't give rise to sort of a constructive dismissal type claim. B, taking into account individual circumstances. So again, think about those things in terms of disabilities, particular reasons why they're struggling to do it. It may just be that they're 200 miles away and that's the problem. But ultimately, you'd get to a stage where you'd be able to require them to come in. So assuming there's nothing untoward, if you've got the contractual obligation for them to come in, then you'd get to the stage where you'd give them enough notice, you'd talk to them about it, but potentially you could compel them to come in, and if they don't, then ultimately you'd end up in a dismissal situation, assuming that's where you wanted to go. Let me have a look at what else we've got here. Question for you, Imelda.
Mm-hmm.
Do you have to do online checks for UK and Irish nationals? Can they still be manual? As I understand, there will be a cost involved for online checks. And there's a question there about whether or not it's discriminatory, considering there is no charge for online checks for EU workers. So, yeah.
Well, it doesn't specify that it's mandatory to do an online check for British and Irish workers at the moment. It is only mandatory from the 6th of April to undertake online checks for those with one of the visa cards, as I set out, so a biometric card or permit and a frontier worker permit. So currently it doesn't say mandatory. So on the basis it doesn't say it's mandatory, you could do an online a manual check until such time as the Home Office decide that they want to go online for everything. They intend to move everything online, and with the introduction of the service for British and Irish nationals, I don't know if they will, when they will decide everything will be online. So for now, it does not say it's mandatory. So for now, it's still okay to do a manual check for Irish and British nationals.
Great.
Excuse me.
Good stuff. I've got a follow-up question, actually. I was talking earlier on about not wanting to return from home. I don't know if it's on answer to the other question or other one, but would dismissal for not wanting to return from working from home, a failure to follow a reasonable management instruction, so some other substantial reason dismissal, not conduct? I think you could probably cut it any which way, in that could be some other substantial reason dismissal rather than a misconduct one, possibly. But I suspect the process and the rationale you'd have for the dismissal would be very similar anyway. So I don't think it would make too much difference. And obviously you still need to bear into account those other factors we talked about earlier on about reasons for why they don't want to return. What else have we got? Do I think the IKEA and Next position is justified? Well, I'm not going to answer it from a moral point of view. I'll leave you to make your own judgment on that. I think from a legal perspective, and I don't act for either of them, so I can't say with great certainty because I don't know the details of what they're exactly doing, but broadly speaking, what I understand of it, I think they probably can justify. They just need to be careful about taking into account the individual circumstances. Where it will cause a problem, I suspect, is where they have a clash between their policy and someone who has either some sort of disability or some strongly held belief or religion that they shouldn't be vaccinated. I suspect those are the issues where problems might arise, but in theory, it's legally doable. How are we doing for time? Nearly running out of time. I think some of these we'll have to come back to, and some of them are a little bit more specific than others. So I'll stick with the broader ones, and we'll come back on the more specific ones later on. We'll come back to you directly. Tips for hybrid working and policies and avoiding proximity bias. I'm not sure I picked that one. I've got 3 minutes left. Well, in short, a lot of it's about clarity. So for your policy and stuff, you just need to be clear on what the expectations are. And I think underpinning it, it is useful if you've got business rationale for what you're doing, because or what you're expecting people to do. So if there are limits on people's ability to do what they want, it's useful to spell out exactly why. Because obviously with hybrid working policies, you are normally for most people, you're offering something to employees they don't already have. So that should be pushing against an open door, but you can still have those circumstances in due course where people are saying, I need something different because of my specific circumstances. So it's useful if you've got the sort of the business rationale behind it, clarity in terms of what's expected. The proximity bias is a tricky one. I suspect it's a training point, principally. So you know, it's making sure that managers in particular understand that they need to be careful, that they're not inadvertently favouring people who are more office-based. You might need to look at your performance review processes, your promotion processes, your salary review process to ensure that there's no sort of unconscious bias in those and there's an objective approach taken. It's those types of things that I would bear in mind. Let's see if I can find another quick one to pick up. Right to work checks, that's probably quite a long one. It's not a short one. Imelda, do you very briefly, Imelda, okay. Is it very brief? Is it easier to get into the country and work here now or before Brexit?
It is easier. The skill level is easier, so there's a wider range of occupations that are available into the skilled route compared to the Tier 2 general route. and the salary is a little bit lower, but the process does have a cost implication.
Just more difficult if you're an EU national, I guess, or potentially.
Potentially, you don't have the English if they don't have English language.
Great. Well, thank you very much, Imelda. Thank you all so much for attending. I'm going to end the session here. If you can stick on and just fill in the very short feedback form that will pop up in a minute, that would be fantastic. There are some questions we haven't got to. We will come back to you individually on those. But thank you very much indeed, and I hope to speak to you soon. Thank you.
Thank you very much. Have a good day.